No compelling reasons had been adduced for detention of the respondent. Number 3, the provisions of the law as cited in the application were erroneous. Number 4, police had already obtained the requisite evidence from the respondent in terms of his laptops and mobile phones. 5, accused rights under the Constitution were being infringed for his continued detention. And 6, the respondent had been previously incarcerated and released on bond in similar circumstances. I have considered the following. Number 1, the provisions of Article 49, Article 25, Article 29, Article 132, Article 50, and Article 159 of the Constitution as referred to by parties. Number 2, I've also considered all other laws as referred to by the parties, that is the Criminal Procedure Code, Computer Misuse and Cybercrime Act, where interestingly, as I researched, under the Petition 206 of 2019, that is BAKE versus AG 2020, Justice Macau held that the act was valid. The other thing I've considered is the Constitution. 5, the case that was cited by Mr. Dumbi. Maybe I should give you the full citation. I did some research. Sudi Oscar Kipchumba versus Republic 2020 EKLR, which I'll discuss later. I also considered a precedent that was provided by the state, Republic versus Joktan, Mayande, and 3 others, 2012. So in my determination, I have considered the arguments by parties in open court, and I am persuaded to look deeply into the law. In the first case of Sudi Oscar Kipchumba, the matter was before the courts. The applicant is a member of parliament. He had been alleged to have committed several offenses, which included hate speech, assault to police officer, possession of firearm, offensive conduct, and resisting arrest. The said MP had been placed in custody for 7 days before going to the High Court and had approached the High Court for a revision of the said orders.